Now we know the names of the judges who will be hearing the challenge to California's marriage amendment, and a federal appeals court tosses out the case of a pro-life nurse. This is the Citizen Link Report. Hi, I'm Stuart Shepard along with Bruce Hausknecht, our judicial analyst. Hi, Bruce.
Hi, Stuart.
Bruce, we just learned the names of the 3 judges on the 9th U.S. Circuit Court of Appeals who will be hearing the challenge to California's Prop 8 case, and that's the marriage amendment that was passed overwhelmingly by the people, placed into the code of California, if you will, placed into the Constitution, and then the challenge came immediately, got defeated at the lower court. I mean, Judge Von Walker struck it down, said we can't have that. Now it's at the appeals court. What's your reaction to hearing the names of the 3 as far as how it will influence the outcome of the case?
Well, we've heard that of the 3, Judge Stephen Reinhart is the senior judge on this 3-judge panel. Now, anyone who follows news about the 9th Circuit knows 2 things: that the 9th Circuit is the most liberal circuit in the federal system, and that Stephen Reinhart is the most liberal judge on the 9th Circuit. So if he's leading that particular panel that hears this case, he will probably write the opinion at the end of it. And from his record, that can mean only one ominous thing, and that is that this case is in for a rough haul next Monday when this case is argued in San Francisco.
I notice you've got a smile on your face as you're talking about it. Why is that?
Well, Stephen Reinhart is so liberal that even the liberals on the Supreme Court will overturn him, and they have for the last several decades. He's probably the most reversed judge in the federal system, and a number of those over the years have been unanimous. So as he likes to say, the Supreme Court can't catch them all. And so he continues his activism as if there is no Supreme Court, figuring that he will eventually get his way.
Let's talk briefly about the other 2 guys who are on this panel. Who are they, and what can you tell us about them?
Right. The other 2 judges are Michael Hawkins, who is a reliable liberal, as I'm told, and Randy Smith, who is a conservative judge appointed by President Bush in 2007. So you've got 2 liberals, 1 conservative on a 3-judge panel.
Which would indicate perhaps, and it's tough to speculate about these things, but in all likelihood, a 2-1 split decision when we're done with the dissent coming from the George W. Bush appointee, maybe.
Yeah, that would be a reasonable guess, and one that I wouldn't argue with you about.
Yeah. Now, Judge Reinhart has quite a checkered history of decisions. Can you give us some of the decisions that he's made, particularly on the social issues?
Yes. For some reason, Judge Reinhart seems to end up, and of course the 9th Circuit draws their 3-judge panel through a lottery. So it's supposedly pure chance.
Absolutely random.
Absolutely random. And yet Reinhart has ended up on most of the socially conservative cases over the last 2 decades, beginning in the 1990s with the famous assisted suicide law that he upheld because he said there's a constitutional right to assisted suicide. That was reversed unanimously by the Supreme Court. Yeah. That began a whole series of cases. He voted to throw out the Pledge of Allegiance because it had the words "under God" in it. The Supreme Court sent back down. It came back up. He again voted to throw out the Pledge of Allegiance. He has been on the forefront of abortion. He's thrown out the federal abortion law when it came through the 9th Circuit that ultimately went to the Supreme Court and was upheld by the Supreme Court. He wrote that decision. He wrote the decision that allowed first graders in a California school to be offered psychological testing surveys on their sex habits and their views on sex. And some parents objected to that, and in Reinhart's opinion that he wrote in the Fields versus Palmdale School District case, he said parental rights end at the schoolhouse door.
I know a lot of parents who would take issue with that particular ruling.
There was an outrage and an uproar about that particular case. Just last year, in a 9th Circuit employment dispute over benefits, that he rendered an opinion that doesn't have any binding effect in the 9th Circuit, but he rendered a decision that declared that the Federal Defense of Marriage Act was unconstitutional. So he's already on record as saying that he thinks that any law that limits marriage to a man and a woman is unconstitutional.
Right. So we pretty much know where he's going to head with this. There have been some questions raised about whether Judge Reinhardt should take himself out of this case, to recuse himself, to use the legal term. What are you hearing about that?
Yes, there was a blog post this morning from Ed Whalen at Bench Memos, who is probably the premier lawyer following this case, and he knows the ins and outs of it. He raises an interesting issue. Judge Reinhardt's wife, who is a lawyer in her own right and executive director of the ACLU of Southern California, was consulted in this case early on as to whether or not to bring the case. And
bring the challenge to the marriage amendment.
Bring the challenge to the marriage amendment. And since she was consulted on that case, it would seem to at least offer some appearance of a lack of impartiality by her husband, who is Judge Reinhardt. Now, this was just raised this morning in Ed's blog, and we'll see if it catches on. But it is at least an important question to ask.
Now, before we move on, I want to mention you will be going to California and get to sit in person as this is being heard. You must be looking forward to that.
I am looking forward to it. Even though the panel seems to be lopsided against marriage, this is a historic occasion, and the decision that comes out of the Ninth Circuit is going to be carefully considered by the U.S. Supreme Court.
All right, we look forward to hearing your report, your eyewitness review of what you saw happen and how they did the questioning there. Now, just real quick, I want to mention there will be 2 hours that they'll be discussing this. The first hour will be about?
Well, the first hour is about the technical issue of standing, and simply put, that is, do the parties that are before the court have a right to be there? Have they been injured in fact? It's been argued, and Judge Vaughn Walker at the trial court level said that the basic defenders of the Prop 8 amendment out there, Protect Marriage, they don't have standing. They don't have any right to be in court because they're not government officials.
Right.
And so the Ninth Circuit has set aside a whole hour of argument just on that issue alone. And however that decision turns out could impact the entire case.
Yeah, and again, that deals with whether only, the question would be, can citizens bring this kind of defense, or is the state government the only proper body, entity to bring the defense of the marriage amendment?
Right, and if the government, in the form of Governor Schwarzenegger and the Attorney General Jerry Brown, who is the incoming governor, they sided with the anti-Prop 8 folks. They want same-sex marriage in California, so they decided let's not defend Prop 8, even though 7 million Californians decided that this ought to be in their Constitution. So if you have a couple of government officials defying the will of the people, someone has to be able to step up and defend that amendment.
I'd like to get your thoughts just for a couple of minutes before we wrap up. There's another case we've been following involving a pro-life nurse, and we got a decision out of the Second Circuit, or actually they tossed the case. Tell us about that.
Right. This is a very interesting case involving a nurse who was forced to assist in an abortion, even though she was on record with her employer, Mount Sinai Hospital in New York, as being against that. And that she wouldn't perform that. And there just so happens to be a federal law called the Church Amendment that says if you accept federal funds for your health care facility, and Mount Sinai gets hundreds of millions of dollars a year in federal funds, then you cannot discriminate against the person if they have a religious or moral objection to abortion. She fits right into that. Yet she was forced to perform this abortion and then later threatened with job consequences if she refused to do this in the future.
Right.
Well, she decided to bring suit and say, look, you're violating the Church Amendment. I really ought to have my rights vindicated here. And her suit was thrown out, and it seems that the Church Amendment, although it orders that there be no discrimination against individuals, provides no remedy for the individual to enforce their rights. I don't know whether it was an oversight of Congress. There is a legal theory out there that says it's implied.
Yeah.
The Congress wouldn't grant a right if there wasn't a corresponding remedy to enforce it. Right. However, the Second Circuit said no, there isn't.
All right. Now, she also filed in state court, and that's ongoing, right?
Right.
All right, so that will continue. Bruce, we look forward to hearing back from you next week after you get to sit in on the Prop 8 hearing at the Ninth Circuit. Look forward to your comments on that. We appreciate your being with us each week here on the Citizen Link Report. We enjoy getting your messages, your questions, your comments on the things we do. And we encourage you to write to us at mail@citizenlink.com and let us know what's on your mind. And in the meantime, remember, stand tall and be heard.